Buying off the plan can be a great course of action. You can select the property you want and it'll be brand new. If the property is to be used as your primary place of residence, you have a 12-month extension to pay stamp duty. That is, you have 15 months in total, provided completion does not take place before then. Ideally, there would also be an uplift in price by the time you have to settle, although some banks refuse to take that uplift into account when assessing your loan application. Buying off the plan does, however, carry risk. Today we will discuss 5 of the important risks of buying off the plan that we see in practice. Buying off the plan, what does it mean? When you buy off the plan, it means that the land you are buying has not been created into a registered lot, either a strata plan or a deposited plan. For example, if you're buying an off the plan apartment, the registered lot in the strata plan will not actually be created until construction of the apartment and when the building is complete. There may be some changes in the shape and size of your apartment which alter the layout on the draft plans found in the contract. Only once construction is finished, a surveyor will draw up the plans and register the final plan. The first risk we will look at is the change in size between the draft plan and the final plan. Ordinarily, a contract for an off-the-plan purchase will allow the vendor to reduce the size of the lot in the draft plan by up to 5%, and the purchaser will have no claim whatsoever. In other words, the vendor can reduce the size by up to 5% and you cannot claim any compensation or terminate or rescind the contract. If the reduction is more than 5%, the contract will ordinarily limit your claim to just being able to rescind the contract. You cannot sue for damages, just get back your deposit. In practice, it is rare for the reduction to be anything close to 5%, but it of course does happen. What is more common is that the property will be reduced by a small amount, such as 1 square metre, if there were insufficient allowances made in the draft plan. For example, the services don't allow enough space for the pipe work. Conversely, a property may actually increase in size and ordinarily you do not need to pay anything more. The second risk involves delays and sunset dates. Even in an off-the-plan purchase for a vacant parcel of land in a subdivision, it will take time to complete the required infrastructure, such as the completion of roads, before the final plan is registered. The registration date in the final plan can only be estimated and can be subject to delay. The completion date on the contract cannot be fixed to any specific date. Accordingly, the completion date of the contract will be variable and it will be triggered by the registration of the final plan and the provision of the occupation certificate unless the purchase is for vacant land only. The contract will have to then have a capped date called a sunset date by which the registration of the lot must have taken place. If registration does not occur by the sunset date, then the purchaser can rescind with no other remedy available and obtain a refund of the deposit, whereas the vendor can only rescind with approval from the Supreme Court. Most contracts will have an extension provision for the sunset date in the event of unforeseen delays, and some contracts do not cap this extension provision. The third risk is the drop in price. While there can be, and there often is, an uplift in price, there can of course be a crash in the market and you are still contractually obliged to settle at the agreed contract price. Purchasers will often ask how they can get out of an off-the-plan purchase contract in such circumstances, but the contract is binding and another ground is required in order to be able for the buyer to rescind the contract. The fourth risk involves inclusions not being what you imagined. Most contracts will allow the builder to replace listed inclusions, such as chattels or appliances, with other inclusions of equal or better quality. This is understandable as the product initially listed in the contract may be discontinued by the time it comes to install the product. But what can upset buyers is that they imagine the final inclusions would be vastly different, usually because they had a different impression from the marketing brochures or the display suite. It is important to discuss with your lawyer what you actually intend to be included in the sale, so that this can be properly listed in the list of inclusions or the schedule of finishes, so that it is detailed and as accurate as possible. The fifth risk, structural quality. With any off-the-plan purchase, there is the disadvantage of not being able to inspect the final product. Therefore, there is a risk that the final product may be structurally poor in quality. A practical solution is to investigate other buildings which the developer and/or the builder have been involved in the past. Purchasing off the plan can be a great investment, but it does carry significant risk. It is critical that you engage a lawyer experienced in off-the-plan purchase contracts. At Maclarens, we are very experienced in these matters and happy to assist you with your off-the-plan purchase.